What happens if you're arrested for a crime and before you can get out of jail, immigration notifies the jail that they want to take you into custody? This is known as an ICE hold or detainer. In order to get an ICE hold means you must have been arrested and booked into jail. Here's how the process goes. First, you're arrested for some crime. It could be anything, from a small crime like a ticket to a more serious crime like driving while intoxicated, to even the most serious crimes, which are felonies. You are then booked into the jail, and at that time your fingerprints are taken and you are asked if you are a U.S. citizen. Next, depending on which county jail and city you're in, if you are not a U.S. citizen, that information can either be reviewed by ICE or is actually sent to ICE, who will review their records to see if they have any immigrant with that name and date of birth in their system. Now, when ICE is checking your fingerprints, if they cannot find anything, there's a chance you may get an ICE detainer or hold placed on you. What is a detainer? It's just a form, a piece of paper that is emailed or faxed to the jail, letting them know that the federal authorities for immigration wish to interview that inmate before he is released and freed from jail back onto the street. So you will stay in jail with an ICE hold until you either A, post a bond, B, plea out and finish your sentence in jail or get probation, or C, get your case dismissed. Now, if the charge is just a ticket, you can pay your fine and be released to come back. Now, everybody who is arrested on a new charge or a warrant for a new charge has to see a magistrate judge who informs them of the charges against them and what their bond amount is. In Texas, if it is a misdemeanor, the police have 24 hours after the arrest to turn in their arrest report or probable cause affidavit. If it is a felony, police have 48 hours. During this time, while they're waiting to see the magistrate, if ICE is informed or discovers they're in jail and they're not a U.S. citizen and decide to place a detainer on you, you will not be allowed to leave freely. Now, here is the important question. What should you do? Do you pay the bond, fight the case from jail, hire a criminal defense attorney, hire an immigration attorney, hire both? An experienced attorney knows that before we know how to answer those questions, we must first discover your current immigration status. Are you currently in the U.S. illegally? Did you last enter the U.S. legally with a visa and inspected? Have you overstayed your visa, or is it still current? Are you a permanent resident? If you're here illegally, have you been deported before? The answers to these questions matter because some immigrants will not be eligible for an immigration bond. For example, you're not eligible for an immigration bond if you have been previously deported, or you have a drug conviction, or you have a conviction for a crime that immigration law requires mandatory detention, such as multiple theft convictions or crimes of violence convictions where you have been sentenced to more than 1 year. An immigration judge can deny anyone an immigration bond if they feel the immigrant is a danger to the community or a flight risk. So knowing that you could potentially be denied the bond, an attorney will need to evaluate your criminal history to determine whether there's a chance the judge may find that you are a danger to the community and what factors you can show to the judge to prove you are not a flight risk. For example, an immigrant arrested for drunk driving who had a really bad accident in which somebody was hurt in the accident and a very high blood alcohol content level may be seen as a danger to the community. Or an immigrant who has only been in the U.S. for 2 years and has no wife, kids, or other family who are U.S. citizens or permanent residents will probably be seen as a flight risk. The second piece of information that the attorney must determine is how serious is the charge you were just arrested for. As we just said, if you are found to be a danger to the community, the judge will not give an immigration bond. That means even if you've never been arrested before and this is your first criminal charge and the case is pending, but it is a serious felony like an aggravated assault with a deadly weapon or sexual assault or child abuse or domestic violence or any case with a victim involved, the accusation may be considered by an immigration judge as too serious to risk letting you out. So if you have a new serious criminal charge pending and you are undocumented, you probably will need to stay in the county jail and fight it from jail instead of risking being moved to immigration custody, only to have the immigration judge deny you bond due to possible danger. Since you have only been accused at the moment, you still have a right to fight the charges and possibly still win your case, which may allow you at a later time to be released by an immigration judge on a bond. However, let's say your new case is not that serious, like a traffic ticket or minor theft or criminal trespass. What are your options? You can bond out from the county jail. You can do that in several ways. 1, you can hire an attorney who can get a personal bond signed by a judge. 2, you can hire a bail bond company. 3, you can just pay the bond in cash. Then, you will need to hire an immigration attorney to draft an application to request an immigration bond hearing in front of the immigration court. Now, what about the criminal case? You already paid the bond. At this point, do you need an attorney for the criminal case? Most likely, yes. Because once you are out on the criminal bond, you are required to go back to criminal court. And even though technically you are not out of jail because you are still in immigration jail, the criminal judge will expect you to come back for your court dates. How are you going to go to criminal court if you're still in an immigration jail? You will need an attorney to explain the situation to the criminal judge and extend your court date and reset it until such time you can attend. Now, it would be best if you had an attorney who was an expert in both immigration law and criminal law, so they know how those two worlds interact and how one case can affect the other, and the timelines for how long things take. An attorney who knows both immigration and criminal law can best explain and communicate to you of what is needed and what to expect. An attorney that has knowledge of both will save you money and keep you from making mistakes that may prevent you from being released to be with your family. So, now that you've posted the criminal bond, after the bond is posted with the jail, ICE has 48 hours to pick up the immigrant. This 48 hours does not include Saturday or Sunday or any federal holiday. Once they have picked up the immigrant, they will take him to the nearest ICE office where they will first confirm his identity through an interview and fingerprints to check his nationality. Second, check both his criminal record and immigration record. And lastly, decide what to do with the immigrant. If the immigrant has been previously deported, most likely he will be deported again without a right to see the immigration judge. In cases where they have been previously deported, ICE can also possibly call the federal prosecutor to decide whether they wish to prosecute him for illegal reentry after being deported. If the immigrant has never been deported, they will probably send him to an immigration jail to be detained until he can have an immigration bond hearing. A very small, lucky percentage may possibly be let out, but this is very rare. This usually includes people like pregnant women with no record, older people with health issues, and who don't have a bad record. Again, this is not very common. The next step is the immigration bond hearing. The attorney has to file a bond application with the court asking for a bond hearing, asking the immigration judge to give the immigrant a bond. Again, the bond is the amount of money that must be paid or deposited with immigration in order for the immigrant to be released. The money stays deposited with immigration until the immigrant either wins his case or is ordered to leave the country, and once it has been confirmed that he's left the country. At that point, the person who paid the bond can get their money back. Likewise, if the immigrant fails to go back to court or fails to leave the U.S. when the judge says, they will lose their bond deposit. So what is in a bond application? An attorney usually will want to submit documents and evidence of the immigrant's life living here in the United States. Documents such as proof of where he lives, like a rental contract, proof that he has a job, proof that he has paid taxes. If he is married, a copy of his marriage license. If his wife is a U.S. citizen or permanent resident, proof of their legal status. If he has children, the birth certificate of his U.S. children. And if the immigrant has other family who are citizens or permanent residents, proof of their legal status. It also helps to have letters of recommendation from friends or employers who are U.S. citizens that the immigrant has good moral character. Also, the immigration judge is likely to ask if there is somebody here who will sponsor the immigrant and take financial responsibility for him while he is out on bond. So you need to have a U.S. citizen or permanent resident who will agree to do that. The next step is the bond hearing. After the bond packet has been filed with the court by the attorney, the court will give the immigrant a court date. The hearing can either be in immigration court where his family and friends may attend, or it is possible it may be held in an immigration jail inside the actual jail, in which case family and friends possibly may not be allowed to attend depending on the court and the judge's rules. The lawyer will be allowed to be with you or sometimes can appear over the telephone or through video conference. The lawyer can bring witnesses to court to testify on behalf of the immigrant or can introduce affidavits from witnesses stating their knowledge about the immigrant. If the immigration judge agrees the immigrant is not a threat and that he is responsible to come back to court, he will set a bond and his family can go pay it the next day. However, if the judge decides that the criminal charges or criminal history makes the immigrant a potential risk to release due to possibly being a danger to society, he has discretion to deny him a bond, meaning he will stay in custody until the end of the case. Likewise, if the judge finds that the immigrant is not sufficiently trustworthy to return to court due to lack of relief or minimal family contacts in the U.S., the judge can deny the bond. If you have been lucky enough to get a bond, but your family does not have enough money to pay the entire bond, they can call an immigration bond company to see if they can help post the bond for less money through a payment plan. The minimum immigration bond the judge can set under the law is $1,500. However, a bond can be as high as $10,000, $15,000, or possibly even $20,000 or above, depending on the immigrant's criminal history and immigration history. You can pay the bond with a cashier's check, a money order, or again, hiring a bond company. Once the bond is posted or paid, the immigrant gets out of jail. Now what happens? Well, first off, you are now free and able to go back with your family and return to your normal life. Your case will continue on, and your attorney will have to determine the best defense for you in immigration court. There are defenses like cancellation of removal, asylum, adjustment of status, VAWA, known as the Violence Against Women Act, or even voluntary departure. How long will this take? The good news is some courts take years to resolve these cases, in which time you can continue living here with your family. Even better news is some of those defenses allow for you to apply for a work permit, which allows you to get a social security number and a driver's license. Now, don't forget, if your family posted a bond for the criminal case, your criminal case is still pending, and you will need to work with your criminal defense attorney to resolve that case. So don't forget, you have to go back to court, and hopefully your defense attorney can get the case dismissed or avoid a conviction, which could possibly result in your removal or deportation. Take it from an expert who's done it for 20 years. This process can be tricky, and you need someone who knows both worlds, both the criminal court and the immigration court. But for many people, there is hope. With some hard work, good evidence, good witnesses, a sympathetic judge, and a little luck, you may be able to win permanent residency. Please contact us if you need help fighting your case, and God bless you.